Larry Lala here. I want to talk about the distinction between using commercial outlines and making your own. So, a couple of weeks ago, I got a question from Awan Sahar, and amongst questions he's asked are on outlines. Specifically, he asked, everyone else says that you should do your own case outlines because you learn by doing. Your guide, the free guide I give out, doesn't mention doing your own case outlines and it's implicit that you should use prepared outlines. Thoughts? My short answer is yes and yes. I say a lot elsewhere about using your own using commercial outlines to study the law, but I still believe you should make your own outlines. Now, these two tools have totally different purposes. You use commercial outlines to start understanding the law. So this is why I say a lot in other videos about pre-studying or side studying the law. You use it to prepare for class to understand cases better. And again, I say more about this particular point elsewhere, but I think it's kind of very often fruitless to keep reading cases until you understand the law. The law is written somewhere in commercial outlines. But it's also a way to get enough law under your belt to begin to take hypos or exams early before other students so that you can master the skill of issue spotting earlier than other students so that you master the end game of law school before they do and get better grades. However, you need to make your own outlines uh, for a couple other reasons. One is while you'll get bits and pieces of the law or start to get an initial understanding of the law by using commercial outlines, making your own outline makes you impose structure on the law so that you can understand how it works as a body of law, how torts works as an entire body of law, or how contracts works together. It's not just you're going to learn a lot of individual cases and bits of law, but how to put it all together. You make it yours by being forced to do an outline. The other thing is by imposing structure on the law, it really wears a groove into your head so that law sticks in your head. That's important for two reasons. Well, one big one is that say that you have a closed book exam, you need to get the law in your head somewhere because you won't have something to reference during the exam. But what's less known is that even if you're taking an open book exam, and I think most law school exams are still open book, you can bring the case book, you can bring your own materials, you can't bring commercial outlines. Um, you're not going to have time to refer to those materials in an in-class exam. You've really got to have most of it in your head. You can use it occasionally as a reference, but that's it. So you need to get the law stuck in your head. The other point is that more specifically, you need to get the professor's law stuck in your head. Your professor's wording of the law is very important. And many times, this is why professors kind of discourage you from using commercial outlines. They often notice students who haven't done work during the semester bringing in outlines or commercial outlines and copying the law from those, which indicates that they haven't followed along in class. To me, this is a starting point, not the end point. By the time you get to the end of the semester, you should have your own outline with your own structure in the law using your professor's words. So let me say a little more about both of these topics. Let's start with commercial outlines. So why do you use commercial outlines? Again, you use commercial outlines to start grasping the law so that you can prepare for class, so you can understand the cases, in my view, better and faster. Uh, and you need it to take hypos early. So what buying commercial outlines helps you do is target two of the three pillars of wisdom and to set the foundation for this one. Very directly, studying commercial outlines helps you master the law. Indirectly, by starting to study the law before you need to over the summer or before it actually comes up in class, you begin to master issue spotting because you have law that you can use to then apply on hypos or exams to build up your issue spotting muscle so that you kick ass on your final exams. And then it helps you master your professor in an even more indirect way, because if you have some knowledge of the law when you walk into class, you can hone in on your professor's idiosyncrasies. You're not struggling, uh, kind of floundering in class to understand the basics, because when it comes down to brass tacks, I don't think that in most of the disciplines that the different subjects that you're going to study, that the law is super complicated. Um, but trying to learn the law from cases makes it complicated, so that very often you're missing what your professor is saying and what they're saying that might be important to you. So here's that pyramid illustration. You master the law. You feed this by reading commercial outlines. You can then master issue spotting. And as you master these two, it makes it easier to master your professor. So what does it mean to master the law? It means mastering the elements and factors uh, of the law, this actual structure of the law. Cases are applications of the elements and factors of the law. Now, where do you get these? A lot of the time you can simply buy commercial outline. Emanuel's or Gilbert's is the common thing, and you usually buy, there's a particular book for each subject: torts, contracts, property. Um, you can also do Convisor, what's called a Convisor mini review. These are not new books. These are sold by Barbary as part of the bar package, but you can get an older one of these on eBay or Amazon, and they'll very often have all of the 1L subjects, because all of the 1L subjects are tested on the multi-state bar exam. This is exactly how I studied. A friend of mine gave me a Convisor mini review, and I took it along with me in a pre-law school trip to Spain. I read it on buses, sitting next to guys in tracksuits smoking. Um, and you don't have to worry about what state you get. You can get the state that you're going to study in, but the multi-state bar topics are the same across the country. So pre-studying the law is relatively simple. What you can try to do to narrow your studying is to get a syllabus. Depends on how far ahead of you are. If you're quite, if you're a number of months or weeks before law school, you might not have syllabi, so it's not too bad to read the outlines like Emanuel's or Gilbert's or Convisor before. If you're already in law school or you're about to start law school and you received syllabi, then you can focus studying just those topics that your professor intends to cover. Most professors don't cover all of the topics that are outlined. But definitely if you're side studying, if you're already in law school, then only read sections of the commercial outlines that are covered by your professor. And put the same amount of time and attention that your professor does on a given topic. If they spend a lot of time in class on a given topic, super study that bit in the commercial outline. If your professor doesn't cover a lot, then don't worry about that. So there's a reason you need to make your own outlines, and why it's kind of a false dichotomy. Why you can both use commercial outlines and still make your own outlines. Again, these have totally different purposes. So you understand commercial outlines are so that you can get a start on the law. Making outlines helps you really master the law by forcing you to impose a structure on the law, so that it's not just a random list of rules, but a whole system that you can use to solve certain legal problems in a given field. Creating this structure gets the law in your head, and because the outline is a compilation of what you write from your notes in class, you're also getting your specific professor's wording of the law in your head. Okay, so you can start with the commercial outline, but that's not the wording you want to use when you're writing your exam. You want your professor's wording, so you go to class. But there's a deeper reason why getting this structure, getting some kind of structure of the law is important, and what it is that you're seeking to do. When you do outlining on your own, so a lot of other students, they don't really know what an outline is for. So they just record a bunch of cases, and there's some kind of general organization, um, But most people just condense their notes and use it to like record their thoughts on different cases. And usually they follow the outline that's given in their professor's syllabus. You should use outlining to do more. It's to help future you with issue detection on a final exam. Now, the point is not necessarily that you're going to be able to use this outline on the exam, maybe you can, but so that your mind has this structure so that you don't even need the physical outline. You can leave it behind, but this will only happen if you actually make your own outline. So I think within an outline, there are two different tools that you should be creating. A claim spectrum, which is a variety of laws organized in a certain way so that you can try and solve a given legal problem, and then a case spectrum within a given issue so that you can resolve specific claims. So I'm going to go in depth on both of these, claim spectrums, case spectrums. Claim spectrum is, so remember what a final exam looks like. It's a totally weird set of facts that you've never seen before with no guidance on what law applies. So a lot of the times what you're looking for in a fact pattern is a given harm that takes place. So let's say you spot a killing in a given criminal fact pattern. I think a good outline will have a chart that deals with, has a section on killings and then organizes them in some order that makes sense. So you would start with, say, intent to kill murder, which is when someone intends to kill, then maybe a depraved heart murder, which is where, something like drag racing, maybe you hit someone, clip someone on the side of the road. You don't intend to kill someone, but it's very likely that someone's going to die because of your recklessness. Voluntary manslaughter and involuntary manslaughter. So it's kind of maybe organized by seriousness, from more serious to less, or from intentionality, from super intentional to didn't mean to kill, but we're going to attribute criminal liability for death. So maybe it looks like this. Maybe you've got a kind of horizontal spectrum where you have intent to kill, and maybe these should be reversed in order. But there's a structure, and you can kind of take a fact and say, test out, is this kind of intent to kill? Maybe this falls between intent to kill and a felony murder or a depraved heart murder. A case spectrum is a spectrum of outcomes on your exam. And this is probably where you take, which requires the most organization. A case spectrum focuses on usually just one doctrine and go through the range of possibilities in order of increasing or decreasing likelihood of liability. Doesn't matter which, but it's a way to kind of help you through an issue, how to resolve one that you spot. So this is the analogy I like to use. You've got a house. The house is a new fact pattern. And here's you. And you've got to repaint the house. You've got paint kind of coming off. So you go to the paint store, you go to Paint World, and there's someone, and you say, I need kind of baby, robin's egg blue. And the salesman's like, what? You want kind of fuchsia? And you're like, no, what are you thinking? What are you thinking? And the salesman's, okay, I can't read your mind. Here's a swatch of paint colors. You tell me. Here. So you take this home and you tell me what color your house is or what paint's going to do the best job. So, okay, I'll take that. Swatch home. Leave the paint store. You walk home and you go, is this, Robbins, is this between red and orange? No, not so much. Is it between orange and yellow? No. Is it between yellow and green? No. Is it between green and blue? No, but getting closer. Is it between blue and light blue? Yeah, maybe so. This is close. So that's visually what a case spectrum is very much like. And I think no one's going to make one of these for you as it applies to the specific cases that your professor decides to cover and how your professor thinks about those cases. So this is a case spectrum that I used for a civil procedure class, okay? A sample case spectrum kind of looks like this, and you kind of array your notes on specific cases. So this is whether there's personal jurisdiction for torts. So torts are kind of generally unintended injuries that aren't covered by contract or property law. And there's a whole series of cases that used to deal with whether or not you could drag someone in court in a particular state based on the contacts that the defendant had with that state and whether or not the accident at issue took place there. So, for instance, Nelson v. Miller, the result is yes, there's personal jurisdiction with a single transaction tort. If the tort happened in, say, California and the defendant doesn't really otherwise spend time there, then it's still fair to bring them into that court. Now, a lot of this case law has changed. This is my outline from like a while ago. So then there's this case Gray in Illinois. Yes, a tortious act can include a defect made outside of the state that takes place inside of the state. So maybe you make defective tires and the tire blows up in Illinois. Yes, you can grab that person. But then there's another case in New York that criticizes that result and says, no, tortious act has to be narrow. It has to be the accident took place in that state, not just a defect that happened outside of there. So you have a range of outcomes here. And you can use this on an exam when you see, say, a personal jurisdiction problem involves an accident that occurs in a given state, or aspects of the accident maybe occur in that state or not in that state. There's a certain way you have to write cases that most people don't do on an outline. You start with the outcome, then a kind of forward-looking general statement of the rule that comes from that case, then maybe the case name, and then the facts. Now, most people write their outlines to begin with the case name because that's the easy thing to grasp, Huckins versus McGee. But on the exam, nobody cares. I mean, this is kind of maybe the opposite approach to the who, what, when, where, why, and how on, say, a history exam. You don't care. What you need to do is apply the law. The law is not the name, it's the doctrine being applied in a case. So what's most useful to you is to know outcomes and then really generalized rules, not even the specific facts, but the most general level of abstraction for that rule, which I call the rule of general application. Okay, so here, it's a defective appliance, but does it really matter that it's an appliance? Not really. I mean, what you're looking to do is generalize beyond the specific product or a specific fact pattern for some future facts that may be slightly different. Okay, so this is combining this case spectrum with the image. Maybe, the red here is definite personal jurisdiction. Then you have kind of iffy personal jurisdiction, and maybe your facts fall here. And then you've got no personal jurisdiction here. So I have more about that in another video. That's probably enough for now. So in the next video, I want to get to we're going to get to Sahar's next question on practice exams.